It is June 18th of 2026, and this is the Court Gallery. In today's compilation, we start with Judge DiSanto's courtroom, where a man's violent history with 2 different wives complicates his bond hearing. Then we move to Judge Simmons's court, where a defendant tries to blame the oppression of the system for her own actions. And stick around for the end, because Judge Aquilina presides over a shocking emergency motion to revoke bond after a baby is hospitalized for THC toxicity, leading to a stunning courtroom admission and a final powerful ruling. The cases are crazy, the excuses are really bad, and it all starts right now.
Let's go on the record in the matter of the state of Michigan. Which one? State of Michigan versus Larry Taylor III, 26404.
Good morning, Your Honor. Good man, on behalf of Mr. Taylor is appearing in front of county jail.
Thank you. Are you okay? Sir, your name for the record, please.
Good morning, Your Honor. Larry Monroe Taylor III.
Okay, today is the date scheduled in this matter for the pretrial. And counsel?
Yes, Your Honor. We're asking to adjourn the pretrial so that Mr. Taylor obtain court-appointed counsel and also to obtain discovery on the case. The prosecutor is also going to subpoena the victim in the matter. And I'd just like to make a short bond argument.
Okay, he doesn't already have an appointed attorney?
No, the way Southgate works is usually they send them a court-appointed attorney form and then they get an appointed attorney.
How does it work when they're
in arraignment?
How does it work when someone's in custody?
They send them a court-appointed attorney form and
to the jail?
yes.
Oh, okay.
Yeah.
All right, adjourn for appointed attorney and discovery. All right, and your warning, so we'll adjourn this to is next Friday, June 26th sufficient, or does it need to be?
Yeah.
Or does it need to be July 2nd?
No, it could be next week.
Okay. All right, that's June 26th at 9 a.m. back at the 28th District Court. And you wanted to make a bond argument. Bond is currently $25,000 cash, surety 10%. No alcohol or drugs unless prescribed. Not to possess or purchase a firearm or other dangerous weapon. Not to have contact with Julie Taylor. Not to return to the home in Rockwood. GPS tether if released. As well as the other standard bond conditions.
Yeah, I think my issue, Your Honor, is he's unable to post the $25,000. I believe it was a bit excessive. I think some of it was based on his history with Miss Taylor. But I hadn't had a chance to talk to him about that. I talked to him about today. Apparently, this is a pattern where Miss Taylor will accuse him of domestic violence and can't. They get out, they get back together. The cycle continues. So he looks like he has, more incidents than he actually does. He has no issue with the tether. He would be staying with his friend at Dearborn Heights. The court would know where he is. The court would know if he's causing any trouble. She lives far away, I believe, in Rockwood. So we'd have no cause to see her. I'd ask the court at least get the bond down to something he can afford to post. I don't think it's fair that he's forced to sit in this situation. He said he's going to recant again. I don't know. But I'd ask the court consider a reduction in bond at this point.
All right. Well, this is the first time I'm seeing all of this matter, and I don't have the prosecutor here to address that. Are the two of them married?
Mr. Taylor, are you married to her? Yes, I believe they have the same last name, so I would assume so.
Yes, we've been together for 5 years. We've been married for more than a year.
Is somebody on their phone taking a picture? Snapshot? Somebody just took a screenshot.
There's something for me to email.
All right, put it to silent, please. Well, there appears to be a third-party witness in this matter as well. And where do you live, sir?
So I was living in Rockwood with my wife, but since we fought a week before the incident, I've been in Dearborn Heights off of Penn Street.
Okay. So who was the victim in the 2018 matter in Southgate for the domestic violence you pled guilty to?
That would be my first wife, Marlena Taylor, whose name is now Marlena Hancho.
Oh, interesting that she's a named witness in this matter.
Yeah, my first wife and my current wife were discussing how to get Larry help. So
Give Larry help?
yes, which means send Larry to jail.
And who is the victim, the named victim on the domestic violence you were found not guilty on from River Rouge?
That would also be my first wife. Me and my first wife had a couple different domestic violence altercations as well.
All right. Who's the named victim for the matter out of Monroe, in 2022?
That is Julie, my current wife.
All right. And then who was the victim for the felony malicious destruction of property? Oh, that's fire police property. Are you currently on probation, sir?
I am currently on probation with Brownstown.
And then who was the named victim in that domestic violence that was ultimately dismissed, it appears, by way of resolution and these
So
other matters?
that was the police officer. I have a assault on a police officer. The domestic was my wife had called the police, and then
Okay, so
they
your
dismissed that
current
because I hadn't even
Hold on,
seen my
sir.
wife.
Sir, I just want to know who the named victim was. Okay. And then May of 23, assault from Rockwood. Who was the named victim in that matter?
That was me and Julie fighting again.
Okay. And then 2016, who was the victim in the domestic violence in Southgate? Was that also
Southgate.
Marlena?
That would be Miss Marlena.
Well, it appears, though, you have a significant history, sir, of violence. And given that you're currently on probation for malicious destruction of property, the court's going to deny the request to amend any bond. Sir, you are on probation for a crime by which you need to learn some skills as to how to control your rage and anger when you are in an upsetting situation. That seems to not be the case. That seems to not be the case for you, sir. because now you're charged again with another assaultive crime because your emotions got the better of you. So that's alleged in this matter. Bond and conditions are continued. Thank you. Oops, wait, I think this, that goes with that. And then we are on the record in the matter of the state of Michigan versus Kelly Borgman, 26765.
May it please this most honorable court, Attorney Rena Mitchell appearing on behalf of Ms. Kelly Borgman. Ms. Borgman, state your name for the record.
Kelly Lynn Borgman.
All right, thank you. And today is the date scheduled in this matter for the pretrial. Your client was arraigned on June 8th, and counsel?
Your Honor, at this time, we're asking that this matter be set for a final pretrial. I was appointed today. I'm in receipt of discovery at this time, so we're just asking for a final pretrial date be set. And also, as to bond, Your Honor, this was a DV issue concerning her husband of 30 years. So we're asking, can there be no assaultive contact between the individuals?
Okay, let's address, let me do one thing at a time. We'll get the new date and then I'll address the bond. Can you see if Mr. Mohammed can come on in for the bond? The bond adjustment, please. And so we can set this for June 25th. Seems to be filling up pretty quickly.
And 9:15.
All right, at 9:15 a.m. Does that work for you, counsel?
Your Honor, is it possible for us to do it on July 2nd? Oh, that's my next house.
Yes. Yes. Okay. Does that work for us, Alicia? June 2nd, July 2nd?
That's 9:45, excuse me.
All right, 9:45 a.m. Okay, and then as to bond, the conditions are as follow. Well, first, it's $7,500, 10% bond with the following bond conditions: no contact with Adam Wade Borgman, no contact with Adam Gerard Borgman or Allison Campbell, not to return to the home on Walnut Street, with the exception of one visit to obtain personal belongings accompanied by a police officer, not to possess or consume any alcohol or drugs unless prescribed, no possession or access to any firearms or weapons, and not to be released without an GPS or alcohol tether from the Wayne County Jail. Defendant does, my note is defendant does own a .38 caliber pistol and no access to the husband's safe as a result of that. And so, counsel, you're asking to amend the no contact to be no assaultive contact?
That's correct, Your Honor. And also for her, it's her son and her husband. If the third party is the girlfriend of the boy of her son, so if you want to leave her on there, that I have no argument. But as to her family members, for her son and her husband, I would ask for no assaultive contact.
All right, Mr. Mohammed.
Your Honor, in regards to the request to amend to a no assaultive contact, we would defer to the court's discretion. It's my understanding that, based off of my discussion with the victim advocate who discussed this matter with the victim, that he has no objection to that and he wants to be able to have contact with his wife. I would request that the court add a condition of a alcohol tether. It's my understanding. Oh, okay, then nothing further. Thank you.
Not to interrupt you, but that way you can save your
Yes.
voices. Your voice. Okay, the court will amend the bond condition from no contact to no assaultive contact.
And Your Honor, is she able to go home?
Oh, I'm gonna get to that in just one moment. With just to confirm, the Adam Wade Borgman is her husband?
My husband, yes.
That's correct.
Okay.
I believe for around 29 years.
All right. Okay, and counsel, Mr. Mohammed, as to my condition of no contact of the prosecution witnesses, are you also asking for the same modification? Are you also not objecting to the same modification? Which would be Miss Borgman's son and son's girlfriend, who I believe, if I recall correctly, they all reside together.
Yes.
Yes, she was arrested also.
Hold on, ma'am. I'm
Oh, I'm
speaking to the
sorry, I thought you were
prosecutor now.
speaking to me.
Nope.
Yes, Judge, we would just defer to the court's discretion.
It would appear to me as though perhaps some new living arrangements need to occur for some people, but. All right, the court will include Adam Gerard Borgman as well as Allison Campbell in that amendment. And then is there a position that the people have regarding Miss Borgman returning to the home?
Judge, my understanding that based on the conversation between the victim advocate and the victim, that the victim is requesting for his wife to be home. So at this time, we don't have a position, but that is the representation of my office, that the victim would like his wife to return to the home.
And Your Honor, they've been married for 30 years, is my understanding.
Okay, you may return to the home.
Thank you so much.
Ma'am, let me be very clear. All right. There are bond conditions in place. Clearly, it appears as though there's issues regarding effective communication and problem solving and resolution at the home. If that is the case, ma'am, you better just walk away, because if you are rearrested for violating this court's order, it may be difficult for this court to maintain the current bonding conditions. Okay?
Thank you very much.
Now some conditions continue. No access to your husband's safe, ma'am.
No problem.
Thank
All
you.
right, thank you. Have a good day.
Thank you.
We are on the record in the matter of Derek Flamont, 2626.
Morning, man.
Morning.
Good morning.
Barely. Okay,
John Goldberg, P 30758, on behalf of Mr. Flamont. Mr. Flamont, please put your name on the record.
Derek Flamont Jr.
all right. Good morning. And so today's the date scheduled in this matter for a jail review. Mr. Flamont was sentenced to 60 days jail, suspended, not to possess or consume any alcohol or drugs unless prescribed, and to be subjected to random testing. That was as of March 18th. And that was on your client's plea to open intoxicants. The court has information that your client tested positive for alcohol April 28th, May 8th, and June 5th. And so counsel?
Your Honor, I received that information. I discussed it with Mr. Flamont. He indicated to me that he did consume alcohol on those 3 days. He was explained to him that he thought that the only thing he told him not to do was to smoke marijuana, I believe. And irregardless, is that word? Regardless of that, Your Honor, he's only 20 years old. I explained to him that even if that was true and it wasn't, then he would still be in violation because He's not old enough to drink. With that said, Your Honor, all costs and fines have been paid. I believe that Mr. Lamont acted improperly. There's no doubt about that. I also believe this was not an intentional act on his part to flout the court's orders. It's my understanding he's gainfully employed, correct?
Yes, sir.
And also you now have a two-person home.
Yeah, I mentioned.
He's now renting the accommodation. Your Honor, I guess that I understand the court's concerns clearly. I explained to Mr. Flamont he was wrong no matter what he believed because of his age and himself at the mercy of the court. I don't believe that this warrants 60 days in jail. However, his determination being by the court. It's my understanding that it was immediate sentencing, that he had a prior matter a number of years ago. However, that was as a juvenile. Is that right?
No, when I first turned 18.
So when he turned 18, and
Well, it's not a number of years ago.
well,
Well, I guess technically because it's two, that's more than one. So I guess it'd be a number.
turned 16. That's why I said it was juvenile. And I think that was under.
Well, tell me about the matter that you have a warrant, sir, out of Ohio for aggravated possession of drugs.
I was not aware of that. I didn't know it was a warrant. I had a lawyer for that.
Well, it appears it's date of warrant was November 24th of 25.
I was not aware. They told me that, my lawyer had told me that I needed to get the money to go to the intervention program down there.
So do you have those together?
I have the money now, yes, but I didn't at the time.
So let's see here. Your client did have a matter out of Malcolmdale that was dismissed, as you stated. There was also a matter out of the 33rd District Court, September of 25 for misdemeanor dangerous drugs that were all dismissed. Improper transport of marijuana, 2 of those. And possession of controlled substance, all dismissed in November. I don't know if that's because of the matter in Ohio or not, but sir, you're 20 years old and you already have all these on your criminal history. For what? And then you're here for open intoxicants. Oh, have you also been to Delaware?
No, I've never been to Delaware.
Oh, sorry, Delaware, Ohio. That's the warrant. Sir, why would you think that, let me ask you this question. If you thought that this court said you can just not use marijuana for drugs, first of all, you thought this court only told you not to use marijuana?
Yeah, it was a miscommunication on mine.
Marijuana only, nothing else, no alcohol, no drugs. You can still use those.
I didn't use drugs. I didn't know the testing was for alcohol, and I do apologize for that.
Well, sir, if you needed some clarification, why didn't you contact back into the court?
I apologize.
And I was very specific, and I'm pretty certain that when you received your information regarding testing, you also received that information. This court ordered you, sir, 60 days jail. This court suspended it to give you an opportunity to stay out of jail. What we tested for that same day was to get a baseline on your marijuana, right? So it wasn't only for marijuana for the testing, but that day it was for baseline testing for marijuana. The court's going to order you to serve 10 days jail, clear up your warrant in Ohio upon your release. We'll suspend 50 days jail and set a jail review date in September. Alicia, which date works for us?
Testing to continue, right?
Oh, yes.
Just want to make it clear.
Yes.
That means drugs, alcohol, marijuana, anything. You got it? It's
We can do the 3rd at 8:45.
All right. Thank you. September 3rd at 8:45 a.m. Oh, you know what? Mr. Gopal's not here that day. Do you mind if we do September 10th? Does that work for us?
Yeah, same time.
Okay. All right. September 10th at 8:45 a.m. And what's your work schedule, sir?
I'm like on call for work. It's I just got a new job, so it's they're just I was in the process. I was supposed to go on Monday to get like we just dispatched, but usually it's every it can be any day. I work on weekends, Sunday out of time. The shit running, but I can call the bus and delay for whenever I get off.
Okay. So then you can start that today and you can make a call when you're here in custody, sir.
Yeah, on my phone, so I don't know his number.
What I'll let you do, sir, is access your phone to write his phone number down, and then you can call him from the jail. You can't have it. You won't have access to your phone when you're in custody. So is your phone in your pocket?
Yeah.
Okay. So have a seat at the table, pull out the phone, write the number down, and then you'll start your time.
The little paper comes with me, or should I like where to jail? The paper can come with me into the jail. What you're saying?
Yes, right, Gordon?
I'm sorry.
The paper can go with him into the jail.
Yeah.
Yes, you just won't have access to your cell phone.
Okay.
Yes. All right. Good luck to you, sir. And we are on the record in the matter of the state of Michigan versus Stephanie Ward, 2513667.
Good afternoon, Your Honor.
Good afternoon.
Can I vote for P 307058? Yeah, from Ms. Ware. Four, please put your name on the record.
Stephanie Ward.
All right. Today's the date scheduled for a jail review, as well as a probation violation. This court sentenced Miss Ward on March 6th on her amended charge of operating while intoxicated. Her original charge of operating while intoxicated, second offense, had been dismissed by way of resolution between counsel. And this court ordered 5 days jail suspended. The court also ordered your client not to possess or consume any alcohol or drugs unless prescribed and participate in random testing, and in addition to some other conditions. And it's alleged now that your client tested positive for alcohol twice.
Start time.
Okay.
Your Honor, that's correct. I've had an opportunity to speak with Ms. Moore regarding this matter. As to the violation of probation, she would be pleading guilty to that.
Ma'am, please raise your right hand.
What?
Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You heard the allegations that were placed on the record, correct?
Yes.
And as to those allegations, how do you plead?
Guilty.
I can't hear you, ma'am.
Guilty.
You've gone over your advice of rights for probation violation purposes with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You understand as well the possible penalty as a result of your plea.
Yes.
And in this manner, the recommendation is for you to continue and complete all terms of probation, pay a $50 probation violation fee, serve your previously suspended 5 days jail plus 10 days jail for a total of 15 days, and that to be served tethered to treatment. Do you understand that's the recommendation?
Yes.
You also understand this court could adopt that recommendation in whole, in part, or not at all.
Yes.
You understand this court could add additional conditions.
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right. Counsel, if you can please order your client.
Ms. Ware, you were placed on probation to the school, correct?
Yes.
And one of
Can you
those,
just speak up, ma'am, when you're answering,
I'm
please?
sorry, yes.
one of those terms and conditions were that you were to test for controlled substances, alcohol, and comply with those tests. Is that correct?
Yes.
And you were test negative for alcohol, drugs, etc. Is that correct?
Yes.
And did you test positive for alcohol on May 11th of 2026 and and May 20th of 2026?
Yes.
And is that because you ingested some alcohol? And,
I can't hear you.
Yes.
and satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. Indicate technical violations 1 and 2 will enter based upon your plea of guilty. Counsel, what should this court know?
Your Honor, Mr. Ware this was a relapse, brief relapse. She's been a great deal getting all of her life straightened out. She has, as the court is aware, she's gainfully employed. She's going to school on a full-time basis, part-time basis, but she's testing for exams every Wednesday. She's changed and increased her job. Rather, she had going to.
Okay. No. Okay.
She keeps pointing to all my notes, Your Honor, so I just wanted to. She's now working as a kidney specialist. Is that correct?
Yes, I work at kidney disease specialist on our fine celebrate.
She also now has full custody of her daughter. She has
I have sole custody of my son. I never had not had custody of my son.
did I say?
You said I got custody of him now, like he was
I-
looking for me or something.
No, I didn't mean it that. She has sole custody of her son. I knew it was a custody situation, but I didn't.
Soul and full means the same thing.
Yeah, it just sounded like he was taking away.
Oh, no, not at all.
I understand.
Understood. Okay. Also, Your Honor, she has completed her community service. She's done everything at Salvation Army. She's done the MAD meetings. She's completed that. She's current with all of her payments. She's scheduled for ARM, the weekend retreat, for lack of a better term. That's
June 27th.
June 27th and 28th. That's already been paid for. She's doing everything she can. This was a slight relapse, Your Honor. She clearly understands that she cannot have even the slightest contact with alcohol. We're not sitting up here telling her, well, she took mouthwash or something like that. She's accepting that responsibility, Your Honor. I'm impressed not only with her honesty, to be quite honest, that yes, I did it and I got all this going through with me, but I'm doing whatever I can to make life better for her and for her son. She's here. Go ahead. Say.
I'm also still seeing that for the guidance center as well. Haven't missed the appointment with them.
Okay. Tell me about your relapse.
So I'm trying to keep my grades good. I have exams every Wednesday, clinicals every Friday. I recently switched over my job just to keep income as well as like staying on top of my school, and I'm doing my scholarship myself. I take care of my son by myself. And at the current moment, I'm paying rent for not only my household, but for my mom's household as well. So it's like,
Why are you paying for your mom's household?
because she wants a car before worrying about her house.
So why is her house your responsibility?
Because the way my life is set up, everybody expects me to be superhero for everyone.
Right. Which is why you're continuing to turn to alcohol to cope. So tell everybody no.
Yes.
There's nothing wrong with telling people no.
It's my mom, though.
I understand that. But it's your mom. It's not your child. Your mom is not your responsibility. Your mom works, right?
Yeah.
Okay. Then her lack of priorities are not your responsibility. That may sound harsh, but that's the reality, right? I understand it's one thing to help your mom out or something, but to be expected to pay her housing when you're a single mom going to school.
And to live with me.
Okay. Then she needs to figure it out for herself. You don't have to be everybody's problem solver. Because at some point, your needs and problems solved, and nobody's going to be there for you. Kind of like right now. So, all right, you have those stresses. So why did you drink prior to your test on May 11th?
More than likely for what's going on, what's taking place in, my life.
Right. So here's my point. Okay. And I say this to give you some perspective because when you're in it, you don't recognize it.
Yeah.
But you are being everything to everybody and you're being nothing to yourself. And being nothing to yourself is contributing to you turning to alcohol to cope. You now have 2 driving while intoxicated or alcohol-related driving offenses in less than 2 years. In less than 2 years. And clearly the people that are expecting you to do things for them really don't care much about you and what you need. Because they're still demanding your energy. They're demanding your energy and your help. What are they giving you?
Nothing.
Nothing. So why would you continue to pour your energy into people that aren't giving you anything, as opposed to pouring it into yourself and your son and your immediate family nucleus of you and your son? It's hard. I'm not suggesting it's not hard. I'm not saying it's not hard. But if you don't do it now, it will get worse the longer you do this. And it's hard because as individuals, especially as women and mothers, we are programmed to do everything for everybody. Right? And we're programmed to do the right thing. But who is this the right thing for? Right. So everything you're doing, everything you've been doing for everybody, who's that doing the right thing for?
Yeah.
Right. And you feel selfish telling them no and focusing on yourself.
I feel strange. Not really selfish.
Right. But you feel bad because you're focusing on yourself and telling them no. Now, if you were to read some certain literatures, you'll see that when you put up boundaries, if people don't respect you and they continue to infringe upon your boundaries and not accept those boundaries, then that tells you that the issue is with them.
I don't want to live with me though, Judge. Don't make me feel this. I don't have
She doesn't
to
have to
look for that.
She doesn't need to live with you. She doesn't need to live with you. She doesn't need to live with you.
I can't have a home sleeping.
But isn't that your responsibility? The way she chooses to pay her bills, is that your responsibility?
You
You have any other siblings?
yes.
Great.
know.
Okay.
So
I'm not surprised.
I take care. I'll take his bill and her 2 dogs.
So do they also reside with her?
So currently she's at my aunt's house because I gave her 2,100 September. I gave her 500 December, and I told her we had to sit down. I said, Mom, let me know before this gets, to a certain amount, because I can't keep giving you lump sums of money. I'll rather pay $2 or a couple $100, versus 5 and 2,100, and I have to pay my own rent. I don't own my home. So I felt like she kind of was embarrassed to say like she needed help again. So she waited until it was like the last minute. So I did tell her no, but now I still have my brother.
Why do you have your brother? How old's your brother?
He's only 20.
Only 20.
Yeah,
Does he work?
not at the moment.
Why not?
I can't even tell you because it's like when I talked to her, she said, talk to your brother about this. And then when I talked to him, he said, well, did you ask Mom about this? And it's like, I don't live over there. So
When did you become the parent?
When she her sons. That's the color.
Like I said, I'm just the hero of the family. That's what they say. But I don't want to live with me. I love her to death, but she did that before. I had a townhouse. She told me she'd be there for a couple weeks. She ended up being there for 6 months. So it's like,
So you talk to Matt with your next appointment as to how to establish your boundaries and enforce your boundaries. Because if I send you to jail, are any of them going to jail?
well, I'm not sure. No.
No, that is what I said.
Oh,
If I send you to jail, who's going to be going to jail? You or them? Right. Right. Do you see what I'm saying?
yes.
What's the status of your license?
I don't know.
No, but the status, it's suspended.
Right. Okay.
Yeah.
And so, how do you get back and forth to work?
Rides or Uber? Well, in fact, Uber.
Does your brother have a license? Does your brother have a license?
Yeah, but I work in school. He don't. My life is built around out here. He pretty much like be in the city.
But he lives with you.
No,
All of this is just happening. Like this is new.
My point is that perhaps, right, his job could be driving you around.
You ever pay anyone driving around and living there?
no, no.
No, he can.
That
No,
said,
he's living here for free.
since you're paying where he's living.
Oh,
Just a thought.
and then it's like I'm gonna have to be dragging him and get up, and it's like I don't want to be late for work. I can't be late
Right.
for school.
You're correct.
So
let me tell you this.
Champions.
So you are on this path. Okay. It appears as though other individuals in your family are on another path. Okay.
Yeah.
Sometimes those paths don't intersect, and you have to continue on your own path by yourself, only the engine driving. You don't have any other cars that you have to pull around behind you on the tracks. That's what you need to work on. You need to chat with Matt. That's who that said your therapist is, right?
Get that going.
Chat with him about that. Because you're telling this court that these stressors are why you drank on for your before you tested positive for alcohol on May 11th to May 20th. You need to remove the stressors from your responsibility. I'm not saying you have to talk to them, but set your boundaries. Because they're continuing to pull your energy, and then you don't have that energy to pour into yourself. And they're not pouring any energy into you. The court will note that this court did indicate mandatory jail for any future violations. When I send it,
He understands that's right.
It's got to see. So we're gonna do that one another.
You know, we're asking that he suspend any sentence based on the circumstances. See if she takes Matt's advice, see if she takes court's advice, and starting to.
And I started like on the weekends, so I won't, if I lose my income or like school. Cause this is my last year and I'm really trying to be done. That was why I switched over my job, because to keep up with my clinical hours.
all right, I'm going to order you to, serve 3 days jail. We're going to suspend 12. Let me clarify. I'm going to indicate 5 days jail on the jail review, 10 days jail on the probation violations. For a total of 15 days. You're going to serve 3 days. Court's going to suspend 2 days. You can report. You work tomorrow?
I work today.
Do you work tomorrow?
No, I have clinicals on Fridays. And my son is currently at Champions Blair Moody.
Okay. So make arrangements for your son for the weekend. You're going to report tomorrow at 6 p.m.
Here.
No, you're gonna report downtown, but you'll get instructions from here as to how to report.
So I'm still here.
Oh, yeah. This weekend, right away, and then the sun set wrong.
Ma'am, if there's another violation, you'll be serving the balance of the 12 minimum.
Yes.
Okay. Stop at probation. Good luck to you. Stop at probation. Somebody will be with you shortly.
This is the state of Michigan versus Alice K 2600649.
Ross Marchino, people. Assistant Public Defender John Lee on behalf of Alice Marie Kane.
Okay. Kane was scheduled today for sentencing. Guilty to the retail fraud second, back on April 10th. There is no pre-sentence report because I advised one was not needed because she has 84 days credit at this time. And there was already, I believe, an agreement for her to pay restitution to Meyer in the amount of $182.20. So that will be the order of the court. The court will credit her time served, 84 days. And order restitution in the amount of $182.20. I'll waive discretionary fines and costs. However, I do have to assess the $75 crime victim rights fee plus $50 state minimum cost. So, Ms. Kane, are you being held on something?
Ma'am?
Do you have any other cases pending right now?
No, I don't.
Okay, what are you being held in court on?
Say it again.
What's happening? Is it Antonia Martin?
Oh.
Can you hear me?
I can hear you. I hope you can hear me.
I can.
Why are you smoking marijuana in the middle of my courtroom?
There wasn't no marijuana.
Put it back up to the screen. No, put what you had in your hand before.
This is what I had. You see it smoking?
Oh, okay. Put it out.
Hold on, man.
You're in the middle of court.
I wasn't in court. I wasn't talking to nobody.
You are. It doesn't matter if you're talking. You're in my virtual courtroom, or you can appear in person. The other thing is adjust your camera so that we don't have to see up under your gown or whatever you have going on. Okay? And when you're appearing virtually, you treat it just like you are in person. Otherwise, you don't get the option of appearing via Zoom anymore. Do you understand that?
Yes.
Thank you. Okay. Ms. Kane, what are you being held on? Ms. Kane?
What am I being held on?
Yeah, why are you in jail? Is it just this matter?
It was a refund case. Retail fraud.
I'm assuming she's only being held on this.
Yeah, that's my house. I don't know why I've been here so long.
Okay. When are you gonna pay your restitution?
As soon as I get out, ma'am. I got money. I got to go to the bank to get I have to get my bank card, go to the bank and get the money. I may not can pay it all at once, but I can, because I got 2 other restitutions to pay.
Okay, well, you need to come up and make a payment plan if you can't pay it all. I'll note that you'll pay this within 30 days, okay?
Yes, ma'am. Will do.
If you need an extension, you have to come up and make a request for that, okay?
Yes, ma'am, I will do.
You're all set. Thank you.
Thank you.
You're welcome.
I can leave?
You are free to go.
Thank you. Ooh, thank you, Jesus. Wait, wait.
Oh my God, help me.
I'm sure we can stay.
For real.
Okay, Holstein, who's representing Holstein?
I'm hosting.
No, I said who's representing, but I don't see your attorney yet. You're representing Antonisha Martin.
Yes, Your Honor.
State of Michigan versus Antonisha Martin 26-01487. Appearance, please.
Good afternoon, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Assistant Public Defender John Lee appearing on behalf of Antonisha Denise Martin.
Okay, Ms. Martin has attempted to resist obstructing officer and a retail fraud cab second. This is a probable cause conference that was scheduled before Judge Buchanan. There's an examination scheduled for Judge Buchanan on June 26th at 9 a.m. Are you continuing to examine?
No, we are not, Your Honor. We have made a plea deal with the prosecutor whereby they will dismiss the resisting and obstructing, and Ms. Martin will plead guilty to retail fraud third.
Judge,
Yes.
if I may, can I just confirm with you briefly, because I show count 1 is resisting, obstructing police, count 2 is retail fraud third. I thought you said attempt, RNO, and retail fraud second.
And it could be right. You could be right. The problem is the clerk's office writes stuff on there and they could have did the wrong thing. It should be assisting, resisting, obstructing. You're correct.
Okay, sorry.
I just read what was written there. Okay.
Got it. Thank you, Judge.
Okay. So the offer is to plead guilty to the retail fraud third and dismiss count 1.
That's correct, Judge.
So you'll treat next week as a plea and she can take her plea before Judge Buchanan in person.
Yes, Your Honor. Thank you.
Did you hear that, Ms. Martin? You have to unmute.
Okay.
Okay, you have an offer. You can appear in person next week for Judge Buchanan on the 26th at 9 a.m. to take your plea, okay?
Let me write that down. You said what date?
It's going to be on the 26th, which is next Thursday.
Next Thursday?
Next Friday. It's next Friday.
The 26th at what time?
June 26th at 9 a.m.
Okay, thank you.
Okay, do you have any
Is that
questions
all?
today? That's
I'll
all
talk
you
to-
have.
Is my attorney gonna be my same attorney?
Yes,
I'll talk to him. Thank you.
you're welcome. You're all set. Is
Goodbye.
Carl Mendenhall here? State of Michigan versus Robin Holstein in 26-00166.
Ross Martin on behalf of the people. And I would note we do have a crime victim present who'd like to address the court when the time comes.
Good afternoon, Your Honor. Dwayne Solithorn on behalf of the Office of Public Defender, and I'm filling in for Melanie Wanji. And this is for Robin Renee Holstein, who is standing to my right.
We have Ms. Robinson as the attorney.
That could be right. It could be Robinson.
Oh, okay, very good. Okay, today was the date set for sentencing. I do have a pre-sentence report that was appeared on the 15th. Did they get that to you, Mr. Silverthorne? Did they get that to you, the pre-sentence report?
Yes, it was in file, and I have it, Your Honor.
Any need to make corrections, updates, or deletions?
I don't believe so, Your Honor.
You can make allocution.
That's right. Basically, we'd ask that the court follow the recommendation. Anything that I can tell the court, I will probably pay out. First, I understand that the alleged victim is here today and wishes to address the court and could probably enlighten the court more than I could. But we are asking that the court follow the recommendation.
And Your Honor, there are two things. One is I would note that no longer an alleged victim, she did plead guilty. And I think that I would just draw the court's attention to the fact that this is her fourth assaultive conviction and this is actually assault. At this point, I do believe the crime victim would have to address the court.
Yeah, they can do so at this time. You can come up so that the recorder can hear your statements. Okay, if you can state your first and last name and then spell them.
Arnon Tierling, ARNON, Tierling, TERLING.
Thank you. What did you want to share?
I just want to say that we've been together almost 5 years. We're trying to build a future together. We finally got an apartment here in Lansing. I'm a veteran, so I was at Holy Cross for 7 months getting transitional housing. I got a voucher. And I'm going to retire early at 62. So we're going to have double income. We have a real future together. And this no contact order is a real, monkey wrench, fly in the ointment. It's been a struggle. My sister had to help me pay rent. And, and it's not like she got away with it scot-free. She's in here in court. She's been in jail. Like, enough's enough. Like,
Enough's enough for who?
Huh?
Enough is enough for who?
For us.
We didn't do this. Enough's enough. You telling her enough is enough?
No, I'm saying the oppression of the court system.
The oppression of the court system?
Yes.
We didn't commit any assaults here.
Well, I didn't want any of this.
It's not about that. You can't, society can't allow people assaulting and hurting people. That's not allowed. And this is not her first assault. She has a history of assaultive action. If her actions land her in jail, you can't now decide that it was the court system that oppressed her. The court system didn't oppress her. She oppressed herself. I don't care if she's available to help you with your rent or not. You cannot come in here and make it our fault that she's in jail.
Well, I wanted to talk to him first, because I don't want to come up here.
You can talk to him whenever you want. This is the time for sentencing. And if you want to give a victim impact statement so that you can share with me how this case has impacted your life, you're able to do that. But what I will not allow you to do is distort what the purpose of the judicial system is. This system is not in place to oppress anybody. And in this particular case, it has not oppressed her. If she served jail time on something that she's already admitted to, it was because she did it. And I think she got a plea deal at that. She had more than one charge. But if she served jail time, that was on her own actions. It wasn't because the court decided we were going to pick on her and oppress her.
The last thing I want to do is upset you.
I'm not upset.
That's why I wanted to talk to him first.
I'm not upset.
Okay, thank you.
Your Honor, since my name has been invoked, or at least I've been referred to, I need to reply. Had I spoken with you, Mr. Tierling, I would tell you that I cannot counsel you or advise you as to what to tell the court.
Okay.
I've been for over 40 years, and I'm very strict about that.
Okay.
I am not going to be tampering with the witness. I would have listened to you,
Okay.
been respectful,
Okay.
and told you that you need to tell the court whatever you feel without any advice or counseling or direction from me.
Okay.
Just so you know.
It's interesting.
Anything else you would like to share, sir?
I just want to beg for mercy to get this no contact order removed.
We also have a bond violation here today. You know, bond violation is a contempt of court order. You know that?
I'm not sure what you're saying.
She's also scheduled today to address a violation of court order that she was not to have contact directly or indirectly with you, or to be within 2,000 feet of wherever you were. And there was a police report filed that states that she was in violation of that and in violation of the order not to have alcohol. How are we addressing that?
Me?
Counsel?
Are you going to admit it?
No, yes, I admit that.
You're going to admit to the violations? Let me have you raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, yes.
Okay. And you understand you have the right to have a contested hearing on these violations, that you both were in consumption of alcohol and that you violated the no contact order of the court by having contact directly with Mr. Tierling. Yes. Okay. Is anyone threatening you to waive your hearing and plead guilty to the violations?
No,
Any promises in exchange for you pleading guilty?
no,
And are you pleading guilty to those violations because you believe you are guilty?
yes,
As to the violation that you had consumption of alcohol and that you were present with Mr. Tierling on or about May 8th, 2026 at approximately 2,200 hours, how do you plead?
guilty.
After this.
Can I
Yes.
say something?
Yeah.
I'm also through the other court, because I received a charge from and admitted that, and I'm sentenced for that. I'm on probation for that, and I have been put on a gram alcohol monitoring system on my person.
He's talking, whatever, I don't know what other thing you're talking about. You had a
Regular GPS,
no, what other court case are you talking about?
Mason.
Okay, so you have a case in Mason.
It's over with now. I'm on probation for that.
Okay, what is the case for?
That was for assault for this police officer. Not assault, excuse me, it was resisting arrest
On May 8th?
last year.
No,
April, yes, in Virginia court.
this is for May 8th, 2026.
This is for this court, ma'am. It's 54th and 55th. This is the second case I have.
You just told me, I'm addressing a violation
Okay,
that
I violated in that county, in Mason, and I served 5 days. I was.
What does that have to do with this May 8th, 2026 violation?
That has nothing to do with that, but I'm still, the GPS was on all the entire year and a half, and since then, I've exchanged that for the program I was crammed. So I'm
Okay,
just saying, so the GPS, I just wanted to let you know, you would acknowledge that didn't need it on, they were taken off here last numerous times. But I just want to let you know that I am on the scram device and I'm been successful.
You've been on scram since when?
Since 8th of June.
8th of June. Okay,
Yes.
so this was 30 days before then.
Okay, I realize that. Sorry.
So
I just wanted to explain to you that I no longer consume the alcohol, but I do plead guilty.
Okay. And what about the violation that you were present or within 2,000 feet of Arnon Tierling on that date?
I plead guilty to that.
Okay, what did you do to make you in violation of that?
We were trying to work things out. I reached out with a last desperate attempt to try to make our relationship work.
And you knew that you had a bond condition that violated you from doing or prohibited you from doing that?
I do that now. I do know
You,
now.
you mean now? You didn't know that then?
I was confused. I had a lot of things going on, but
What part was you confused about?
that we wanted to be together. I just wanted to be with
What part of the court order was you confused about?
Actually wasn't then. I'm sorry. I apologize. I take that statement back.
I'll accept your plea to the violation. That's fine. Your plea will be voluntarily and intelligently made. The other concern that the court has, and sorry, unless you have another statement, you can have a seat. The other concern that the court has is that the PSI denotes that she has current bond bench warrants. This was on the 15th, so unless she's taken care of those within the last 3 days, says she has a bench warrant of the 62A District Court and a bench warrant in the 63rd District Court.
My probation officer is aware of that in Mason. She told me that she would.
We're all aware of it. Here.
Oh, I'm just saying, I was just told that through that court.
Oh, you didn't know?
I live in Kent County and I reside in here now. I did know that. I believe, yes, I'm not gonna acknowledge that I won't say that I don't. No.
Okay, what are you gonna do about it?
I have to take care of it once I'm off of probation for this county, for Mason County. Take care of it as soon as possible.
Yeah, not once you're off probation.
No, well, I'll take care of it as soon as possible. I haven't left the city of Lansing at all. I don't have transportation, so I'm just saying. I would like to take care of it. I just haven't been able to. I'm trying to establish a homestead for myself since I haven't been able to return home and just try to stay sober as I can, follow the rules. I made a mistake and I'm working my butt off to correct it, accepting the responsibility of it. I'm also working with mental health. Initially, we were trying to get into the mental health court for myself.
I remember
that communication. I believe, this might have been in and out of trouble myself. And so now I'm currently seeing a psychiatrist there. I have a therapist there.
At community mental health?
Yes, ma'am. And I also have medication and I have a case manager I see once a week.
Okay, very good. What else are you doing?
I started this regimen about the weekend. So just continuing that.
So you started a regimen for the weekend?
For the medication.
Oh, okay.
Got
it. And then are you in any treatment for alcohol?
I'm on a SCRAM program and I'm wearing a SCRAM tether type deal. So no, I'm not in any alcohol programs right now, but that is a total deterrent for myself. That may seem fun.
You need to have treatment.
Okay.
You were in a SCRAM tether is for them to monitor the alcohol.
I agree.
But you need some tools.
I'm not indulging.
To help you.
I agree.
So that alcohol is not an issue, even when the tether's not there.
I agree.
You understand that?
Yes.
Mr. Solomon.
Note that I asked the court to file the recommendation. One of the recommendations was 12 month probation, and I think that clearly would be good that she maintains the whole by the way of the form of probation. I would also note that the court gets a lot of cases of this nature. We get a lot of cases of this nature. One of the most difficult things to do. Had she been my client, I would have taken pains to let her know that the no contact order to a layperson thinks that, well, if the person that's the protected person doesn't care, then it's no big deal. And I always make pains to let them know that the court views it as a direct affront to the court's order. It is a disrespect to the court. It is a thumbing the nose at the court's order, irrespective of what the
victim or alleged victim states. They have really no part in that. And it's for the protection of that person, because particularly in domestic relations situations. I don't know if that discussion was ever had with Ms. Holston. I would have had it. And I think it's clearly both she and her significant other, who is the victim in this case, probably it would be nice if someone could communicate that to the victim sometimes too, because although they're not under the jurisdiction of the court, it would be good to advise them, because as the court can see, there is a participatory element in these cases. Thank you.
So the victim wants me to take the position that enough is enough. He was the one who called the police on you at the time of the violation. The no contact order will stay in place. If you think that law enforcement in the court wants to continuously deal with domestic violence situations, we do not. I don't care how your rent is getting paid. What's more concerning, what I do care about, is the fact that you were a victim of a knife being thrown at you, and you were then stabbed by the person you were allegedly in a relationship with. That's what I'm concerned about. And she's pled guilty to that. This is not her first time pleading guilty to an assault or even aggravated assault. So she's got some self-reflection and some self-work she needs to do. She's not in a position to be in a relationship with anybody but herself right now. She's not in a position to move forward in a future together with anybody but herself. She's got to work on her mental health. She's got to work on her sobriety. She's got to work on her self-control. She's not a good partner for anyone right now but herself. And so it's not a position of the court to go ahead and grant a release of a no contact order just so that your money can flow better, because it's two incomes, just so that we can end up along the lines with another assaultive action on the court. Something worse could happen. And that's not healthy. That's not okay. Maybe after she gets the help she needs and she's in a healthier state, maybe she'd be better a person to be in a relationship with, and the court can consider that. But the court can't consider that today. So the no contact order will be in place during the term of probation. I'm going to adopt the recommendation of probation. There is a 12-month term of probation that will be ordered. And you have the following conditions while you're on probation. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance. How long are you on scram tether?
For a year, I believe.
Okay, while on probation, you are required to submit to random preliminary breath testing and or urinalysis testing as directed, and you have to pay the cost of that. I am noting that I'm not going to require you to do alcohol testing while you are on a scram tether, but I do want random drug testing, okay? There are no bars or nightclubs allowed for you while you're on probation. Do you understand that?
Yes, I understand.
There's no assaultive or threatening behavior while you are on probation. Do you understand that?
Yes, I understand.
I'm continuing the no contact order between you and Arnon Tierland. You cannot have contact with him. I don't care if he calls you. I don't care if your son is staying at his house and your son wants you to come by and see him. If your son's staying at his house, you tell your son, I can't come over there because there's a no contact order. You understand that?
Yes, I do.
Okay. There is no reconciliation during this time. There's only prayer for one another. That's all you can do. There's only love from afar. You understand that? And if he truly loves you, he'll be there waiting for you when you get healthy. Do you understand that? Okay. And so you are going to participate in outpatient substance abuse treatment. You're not employed, but I believe that, are you on social security?
Yes, I am.
You're gonna maintain your treatment with community mental health?
Yes. They also have therapy groups and different groups for even substance use.
Okay, you need to provide evidence that you are maintaining your mental health treatment and counseling, and your relationship with your psychologist, and you'll sign any necessary releases with probation, okay?
Okay. I have the information with me right now, so.
Very good. There's a $30 plus oversight fee that you're responsible for each month of probation. $75 crime victim rights fee plus $50 state minimum cost. I am gonna waive discretionary fines and costs. 12 months of probation is $360. Plus your statutory fines and costs will make it $485 total for your costs, and you'll make monthly payments on that, so that's about $40 a month, okay?
Yeah, I can do that. Thank you.
Okay. Do you have any questions at this time?
No.
We're checking with probation before you leave, and you'll be reporting to them, or you have the ability to report to them remotely each month, okay?
Okay, thank you.
Any additional matters for the record?
Nothing.
Nothing, thank you.
Creditor time served on the violation.
No, I'm fine.
Yeah, okay, we'll get her down to probation. Oh, that's hers.
Mr. So I probably catch Mr. Reed. Because his that was his police down.
Mr. Mendenhall? Treatments we get.
That's what I have to.
All right, this is docket 261485 FH, and I also believe it's 24833 FH. But we're gonna deal with that separately, and we don't need to talk about that file, but we're going to deal with it under the 26th, as we've done before. Acceptable?
Are we referring to the probation violation? Is that what?
This is an emergency motion regarding bonds.
You're right. You just mentioned two files, the 23 file. So
there's a no approach. I just don't cover. Right. So we're dealing with both, but we're only dealing with it under this one.
Yes. The emergency bond was in this file, in reference to the pending case.
Yes.
But I understand. I'm just going to talk about this one. That means.
Yes.
Okay.
But it would all apply to everything would apply to both files.
Okay.
Right.
Yes.
Because of the. Okay.
I am asking that you would.
No. That's what I'm. You're here, right?
He had it.
You're here.
Yes. But
No, this one, they only want to do one file.
She doesn't want to talk about it because it's home, right? So she doesn't want like the public to know she still has that special status.
Yeah. So if we're going to talk about one file, it's going to apply to there because this is and that's how you do this order too. Yeah. Okay, but we're talking about one file. Technically, it applies to two because of this. I just wanted. Thank you.
All right, and this is the people of the state of Michigan versus Ashley Page. Barnhill, counsel, your appearance for the record.
Good morning, Your Honor. Andrea McCray, appearing on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, public defender, appearing on behalf of and alongside Ms. Barnhill in the place instead of Ms. Melanie Wanji, who is unavailable.
Thank you. And this is the people's emergency motion regarding bond.
Thank you, Your Honor. We got a very disturbing voicemail from the father of this child, who is also the victim in this pending case. And it was to Mr. Buxton, you know, really begging for somebody to do something because CPS wasn't doing anything. And
That is not a surprise.
Correct.
They called?
Yes, yes. So, and that's part of what I'll get into in this argument. And what I'm asking for fundamentally here, Judge, is that you revoke her bond. And I will go through all of the reasons I think that is absolutely necessary in this case, not only to keep the community safe, but to keep these children safe. Because this defendant is a danger to not only her children, but to any child. So let's talk a little bit about where we're at. She's on she has another case. I'll say that with this court. This court has jurisdiction over her on a case. And that case, Your Honor, I actually remember that case when I was your docket prosecutor a few years ago. And why do I remember that case, Your Honor? It was a CCW, but there was another component to it because the victim's, the child's father, right, who's the victim in this case,
Was the victim there?
Yes. Because he called police and said, this defendant tried to hit me with her car. We couldn't proceed on that count because he didn't want to get her in trouble. You know, he wanted to work things out with her. She was 12 weeks pregnant at the time. So she's driving a car, allegedly, trying to hit the father of her soon-to-be child, which is the victim now in this case. And how does that argument start, Your Honor? Over marijuana. Over weed. And I'd like to point out that I read her the PSI for that case, and she told this court and the PSI writer, oh, I stopped marijuana. I stopped all of that when I found out I was pregnant. Incorrect. By her own admissions, at 12 weeks pregnant, she's trying to get marijuana and ingest marijuana. So now let's talk about the case that she's currently on bond for. Okay, this is a child abuse third case. And how does this start about? The child, and not just a child, we're talking about a 12-month-old baby, right? So she gets into it with the father of this child. He's making some sort of cake for someone's death. And she's mad that he's spent money on that cake, probably because it's taking money away from, I don't know, maybe some illicit substances. So what does she do, Your Honor? She throws the cake to the ground. And then he grabs her phone, and in an effort to get her phone back, she uses the 12-month-old baby as a bargaining chip, grabs that baby so tightly around the arms that it leaves red marks on the arms of this 12-month-old.
Can I interrupt you? Was
Yeah,
she
of course.
with the victim? Because there's a no contact order. Is that how she knows about the cake and throws the cake?
If there was a no contact order as part, so the cake incident is those facts are why she's on bond right now, to Your Honor. And I don't believe there was a no contact from the CCW.
Okay.
Does that make sense?
Yes.
Okay.
So
So
I will have to check, but this is prior to what you're talking about is prior to entry of the order amending bond. That was very clear that she would be on a tether and there would be no contact.
so I believe the order in April, she was on a tether and she was allowed to. Okay, yes. I'm not alleging that she has had contact with the father.
Okay.
Does that make sense?
Yes, I just want to make sure that
Yes.
predated April 15th.
Correct.
Okay, thank you.
And so he gets the child back from her, and just so we're aware, that child has red marks on her arms when police get there. So that's how tight she was holding this kid to try to get her phone back from the father. And He takes the kid, and what does she do in response, Judge? She takes 2 knives, follows him, tries to get in his face, and then begins stabbing the wall. While the child is still there, over what? Money? I mean, that's so what I'm saying, Your Honor, is that is incredibly dangerous behavior, right? We are seeing an escalation. We're seeing this pattern of violence. We're seeing this pattern of her putting herself, her needs, her wants above children, above her own child, and above a baby. So now let's talk about, you changed the bond to allow her to have supervision with her children via her mother, Catherine Bizzatti, or CPS. Between June 6th and June 7th, the child is now 14 months old, was admitted to the hospital for a marijuana overdose. Okay? And this 14-month-old was asleep for 15 hours, which Your Honor knows well with children. That is incredibly dangerous. They need to eat every 3 to 4 hours. And the fact that that baby is completely asleep for that amount of time is very dangerous. And so how do we find out about this? Well, it's not the defendant telling CPS. Nope. It's not them telling the father. Nope. In fact, there's kind of sort of this cover up where the dad is saying, well, when can I come get my child? And on that Saturday, grandma is saying, oh, we might have a birthday party the next day. Oh, I don't know if she can come home while she's in the hospital. Your Honor, grandma, right, who this defendant had told you could be the supervisor for this child, right, when she has contact with this child. On June 12, 2026, she told CPS that she had expressed to both the baby's father, right, and this defendant, she'd already expressed to them that she no longer wants to supervise the visits because she is too old and has a life of her own. When they discussed with her the marijuana, she advised she uses edibles and her estranged husband smokes. CPS asked her if marijuana is kept in the house. She said it's in her bedroom. They asked if any could have dropped that the child could have gotten into or been in her bedroom. She said it's possible because there are always a lot of kids running around the household and she can't keep up. She stated everyone uses marijuana, and she treated the situation as less significant than it was. So I'm not sure what kind of weed funhouse we've got going on here, but it's completely unacceptable. They interviewed her on June 8th, right when the child had gotten out of the hospital. And just so we're clear, Judge, grandma actually told this defendant, you gotta take her to the hospital. Why? This 14-month-old is lethargic. Her eyes keep rolling back in her head. She's not able to walk, and she refused a bottle. Where's the defendant? Where is she to notice this? Why isn't she taking this child to the hospital? Why doesn't anybody care?
Well, and let me be clear. This is bond conditions. On the other file, she's not to be in the presence of any third parties who have marijuana. So we have a couple of different files with multiple problems, apparently. I've heard from defense, but there's multiple issues going on here. So CPS is involved now?
CPS is involved, and I want to talk a little bit about that next. Okay. So they did actually meet with mom, defendant, and grandma last night. Mom is refusing, defendant is refusing to adhere to a safety plan. They said, please leave, take this child, put this child with a relative. And what does this defendant do? She says, I'm not giving the child back to the dad. Nope. Here are 2 names of relatives that the kid can stay with. Doesn't provide a last name. Provides an address. It's the same address as grandma. Grandma who has told CPS, this is too much for me. Grandma who has said there's marijuana everywhere in this house.
Now let me interject that my order of April 15th says very specifically, ma'am, because you just put up your hands like this, like something's wrong here. And I'll wait to hear from you, but it says follow all family court orders, recommendations, and all recommendations of CPS. That would be a recommendation to CPS is what you're telling me. Is that correct?
Absolutely.
Thank you.
Absolutely. She's not complying with the safety plan, because guess what? They said put the child with a relative. And you know what? Where was the child last night? Still with mom, still with grandma. It's not with somebody else. And also, interestingly enough, they asked her, hey, will you take a drug screen last night? She says, no, I'm not taking one. She says, I'm taking one tomorrow. Which I guess, I don't know.
Did she pay for it?
She did not.
Okay, guess what we're gonna do right now? We're gonna take a break. Ma'am, you're going downstairs for a drug screen right now.
I asked that an officer.
I'm going to ask the deputy. Can we have a deputy escort her down to probation for a drug test? Thank you. We are back on the people of the state of Michigan versus Ashley Barnwell. This is a alleged violation of bond as well as probation. And we just sent, or I just sent, defendant now for a drug test. Do we have the results?
We do, Your Honor. So for what they test for, they don't test for marijuana, but she was negative for. Why don't you just come and say your name and who you are?
Supervisor Benoit. We tested her for infection.
Your Honor, if she could stand closer to
Yeah, well, she can't. Why don't you just come up here?
That mic doesn't. Andre, that mic broke.
Oh, I'm
just gonna. You raise your right hand to swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth and the penalty of perjury.
Yes.
You put your hand down. Please state your and spell your name for the record.
Supervisor Leslie, Leslie, Benoit, Benoit, on probation.
Thank you. And you administered a drug test. Was it positive for anything?
It was negative for amphetamines, cocaine, fentanyl, methamphetamines, opiates, oxycontin, and tramadol.
However, you don't test for marijuana anymore?
We don't have those on our instant test, no.
Did not know that.
That's what we send them to the lab, or normally we send them to like AverHealth or something like that to get those, because they do those tests. But in our instant tests, the office do not have THC on them any longer.
So we need to change that, because all of my orders, and I think my colleagues, say no marijuana. So, okay. So, the sample that she gave, can that be sent?
This cannot. We could urine test her and send that one out, or we could send her to AverHealth and have her test today.
Oh, she's not going anywhere, I think, but we'll see. But she could give another sample and we can test
We could
that.
do a urine sample.
All right. Appreciate doing that. Thank you very much.
Yes.
And Judge, I think there was I don't know if the court received an email from probation downstairs regarding a statement this defendant made downstairs about we'll see what happens. We'll see what's on the test. So it's not like she's even denying that something would come up. Further, she refused to be tested yesterday by CPS. Of course, I'm conjecturing at this point, but if she really had nothing in her system, what would she have to hide? Your Honor, I am asking again that you revoke her bond. It's not appropriate for someone like her to be out in the community. She's a danger to the community. She's a danger to her children, and she's a danger to children in the community. Not only is she not following what CPS has asked her to do, she's not safety planning. She's not following what they've asked her to do. She didn't report this incident or her child's hospitalization to CPS. She didn't tell, frankly, anyone. Thank goodness for the child's father calling Bart, just begging for someone to help, because no one is helping this child. And so I come to this court and I beg Your Honor to do something to help this child, because this defendant is not going to do anything. For all those reasons, I'd ask that you revoke bond. If you are inclined to not revoke bond, I have a whole list of conditions I would ask that Your Honor put on, like that she immediately hand that child over to CPS immediately.
Where is the child right now?
I presume with grandmother at the house.
So father was denied picking the child up?
Correct.
Okay.
Correct.
Okay. Well, let's not get to those requests right now. We hear from the counsel and defendant. Sir, if you could come up to the podium with your client. Ma'am, please raise your right hand. You swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury.
Yes, ma'am.
Thank you. Put your hand down. Have you taken any illegal drugs, marijuana, alcohol yesterday or today?
You want me to be honest? Yeah. I thought
I want you to be honest. I thought you were sorry.
I thought I don't know what I was coming here today, but I was scared and I smoked yesterday. Someone handed me a joint and I hit it.
And you understand that's for probation and bond conditions, no marijuana, not to be in the presence of it, not to use it.
I am aware, Your Honor. Yes.
Okay. And are you still feeling the effects of the marijuana?
No.
Are you supposed to have medication that you're not on?
Marijuana. I have a med card and I'm bond, so I'm not allowed to smoke.
I
haven't been, but
you are
I
with
stopped yesterday.
Ma'am, you are with the medical card. If you gave that to probation, did you give that to probation?
Yes, I did.
Well, did you use it as prescribed or not?
Yeah. I mean, I haven't been using it as prescribed because my lawyer told me my bond I couldn't.
Well, you can accept it for medical reasons. You can. I'm not a doctor. I don't override doctors. But that was not even raised, to my knowledge, when you were in front of me for bond. And I have no notes about that. But okay.
And I've been emailing Miss Wanji trying to get her to talk to you about that. She won't return my phone calls, my email. But I haven't heard from her.
You have pretrial services and you also have a probation agent.
Yeah, and then she told me my lawyer needed to amend my bond conditions. I'm not allowed to smoke while I'm bond probation. They don't, So she talked to my lawyer and said they need to.
Okay. All right. Counsel, what would you like me to know?
Thank you very much, Your Honor. The first thing I'd like the court to know, and the court knows it, but for the purposes of the record, I have not been the attorney of record for this Ms. Barnhill since the inception of this case or for any other case. I appear before the court on her behalf today, equipped with a pleading I received from the prosecuting attorney's office titled People's Emergency Motion regarding bond. I was presented with that. I have a copy of this court's order of 15th day of April of this year regarding bond. And I have a police report that was authored by the Lansing Police Department from an episode concerning the child June 6th or 7th of this year with respect to the hospitalization.
Thank you. I have all of that. I do not have a police report. Thank you.
And so my comments are offered in that light.
Did you need more time to review or talk to the prosecutor or your client?
No, Your Honor.
You may proceed.
Thank you. What I have gleaned from this information is that if you think of it as an equation, there are certain factors that, in my judgment, should be considered by the court, such as my client's mother, Ms. Fezat, F-E-Z-A-T-T-E. She has an address on West Howe Avenue in Lansing. And apparently she spoke to law enforcement and made comments to the extent that lots of folks that come over to her house smoke marijuana. The other factors are marijuana itself. The pleading that I've alluded to, therefore the people respectfully request this honorable court amend the defendant's bond to include a full no contact order with Helena Mendoza Smith and all other children. I don't believe that to be the remedy for the situation. I'm reading in the pleading that there are these allegations these new allegations. It's new information, to be sure, but I don't see any allegations. No one is, it's being deduced without evidence that somehow Ms. Barnhill is responsible for giving the child marijuana or allowing the child. And I don't think that there's any evidence to support that whatsoever. The comments of her mother, Ms. Pazat, were pure speculation. She was guessing as to how in the world the child could have ingested marijuana. So I don't see that as factors to be considered. What the problem here is marijuana. It's not depriving these three children of their mother. The children didn't do anything. And in reading this court's order of 15th of April, the court didn't just indicate $25,000 PR bond and, GPS tether, the normal sorts of things that are accompanied with a modification of bond. The court also recognized and included that she should continue to see her children. She's got three. One, the oldest is 8 years old. School just let out for the summer. She has a 2-year-old, and of course, this youngest one, 1-year-old, Helena. And it seems to me not to be in anyone's best interest to punish these three children by depriving them of their mother. I think that the problem is marijuana. So if the court would see fit, I propose that my client and her three children no longer reside at or visit grandma at her house on Howe Road. Ms. Barnhill has indicated to me that she does have an apartment and she does have an adult staying with her, share the rent, so forth, who could act as a supervisor of those visits if the court saw fit. My understanding, and I've not seen any CPS reports at all, my understanding is that right now it's a week on, a week off, a week on, a week off with the biological father of this child. And if you take the marijuana out of the equation, we don't have a bond violation. We wouldn't have a hospitalization. No child would be in any danger from exposure to marijuana or anything else. So I think that is the remedy that would please the court. With respect to a probation violation, as always, that's wholly discretional with the court. But with respect to the motion to order that this woman had absolutely no contact with all three of her children, it doesn't make sense to me, and it doesn't, frankly, get at the root cause of the problem. So that concludes my comments. Thank you.
Ma'am, what would you like me to know? I would like you to know that Trayshawn, I heard he made the call, whatever it is concerned. He's also the person that didn't get the memo about CPS telling me I have to have someone else. Like, okay, I gave them names, numbers, last names of my cousin, other people that could take my child for me in the meantime. He called my mom. My mom is his babysitter. That's why my children were with them when I was in jail, because I couldn't watch them. So they have my mom take care of the kids if I can.
This is the mom who leaves marijuana around.
Yeah. And then you told me that she had to be the supervisor.
Well, nobody explained to me about her marijuana use, that it was in the house or any of that. And that was supposed to be verified by, I believe, either pretrial services or probation. So we'll deal with that. What else?
And I'm not keeping he gave us the kid. That's why we have the kid right now, because he gave us, her. So I'm confused as to, she's saying all this stuff. I wouldn't follow the safety plan. Yesterday, I helped the lady make the safety plan. So I'm confused.
So do we need to have a hearing or get her on the phone? We can ask, because if you lie to this court, it's 93 days contempt, 93 days under $7,500. I suppose you don't have the $7,500. I don't have it either, but you got 93 days. Additionally, if the father came over and asked for the child and there was an issue, why didn't you give the child back to the dad?
We did. I'm confused. He never
What?
asked for this child.
Okay, we can have a hearing. I got all afternoon. And let me
I'm just
ask you
about
if you
when
drug me
she-
in 93 days.
Fox, you don't, okay? You only speak when she asks you a question.
Thank you, counsel. So I am unclear why it took the father to get this child or your mother to get this child to the hospital and why you didn't call or take that child to the hospital.
I did. I'm the one that took her to the hospital. I saw something was wrong, and I'm like, I should take her in, shouldn't I? She's like, yeah, it looks like she's having a seizure. Like, we didn't know what had happened. So I'm like, okay, I'll go take her, you know. And I took her to the hospital.
Child is what, 1.5 or 14 months? How old?
Yeah, 14, 15 months, yes.
Where were you? I've got 5 kids.
I was
14 months. I'm following them around. I know whether they're getting into something or not. Why is that child allowed to go in your mother's bedroom where you know there's marijuana and then he just probably gummies that she thought was candy? Where were you?
I was doing the laundry. I was in the laundry room.
You don't know the exact moment the child may have ingested
Well,
something.
yeah, but that's the only time I took my eyes off of her, was when I was in the laundry room. I was with her otherwise, so.
Anything else you want me to know? Yes or no?
There's a bunch of stuff I want you to know, but nobody really cares what I have to
Ma'am, I'm here. I'm listening. I've asked you. If you don't want to speak, then don't. But if you do have something to say, I've always taken time to listen. So what is it you want me to know?
I don't have nothing to say.
Okay, I'm handling people.
Your Honor, CPS is not doing it. The real problem. Well, I think this is defendant is the real problem. Not marijuana. No, we have all these adults in the house and nobody's watching a 14-month-old. That's absurd. What did she do? Laundry for half the day? Give me a break. Your Honor, CPS tried to safety plan with her and said, put the child in a relative's home. She gave them, here, I got the notes right here. She emailed me the names of Marcy Guzman and Vanessa Guzman. The phone number provided was X. She was asked to provide any other last names and addresses where the child would be present. Several hours later.
Hey, could you spell the last name, please?
Guzman.
Thank you.
She stated Conrad. Stated there was no other last names. The phone number was not a working phone number, and the address is the address of her mother. It was clear Ashley was not willing to cooperate or comply with a safety plan. She worked with CPS yesterday on a safety plan, another one, because she wouldn't do the other safety plan, and CPS won't do anything. That's the problem. So sure, she's working with CPS, right, because she says, oh, I'm not going to give my kid to this fake relative or this address of my mom's house. And CPS says, okay, well, I guess we don't have any, we don't have any backbone, so we'll just do whatever you want. So you want to get our paperwork in order, whatever. So they don't do anything. So now she says, well, I'm complying with the safety plan. That is it. And that is so inaccurate. It's ridiculous. I don't have anything else to say.
Thank you. Counsel, anything further?
Your Honor, I have no information with respect to a safety plan or CPS involvement. I don't know. I'm unable to assist the court in that regard. But it is, I think, significant that it was Ms. Barnhill herself who took that child to the hospital. And the biological father, there was a no contact order, so it would be improper for her to notify him by telephone or to have someone else in her place notify him. I don't know how he came to learn about that, but I just wanted to indicate to the court that I don't see this as this woman harming or wanting to harm her child.
Well, keep in mind, counsel, the allegations here are assault with a dangerous weapon, also known as felonious assault, a 4-year felony, child abuse, 3rd degree. She knowingly and intentionally caused physical harm to a child, and that's a 2 years or up to 5 years probation, and then domestic violence. And this file, now these are only allegations. There's been no resolution on this, but on a previous file, the domestic violence with the same defendant, with the same victim father, there was a domestic violence which was dropped as a part of a plea. So, man, what would you like me to know? Anything else?
Anything you want to ask me, but I don't know what to say.
Have you undergone a psychological evaluation?
Yes, I have.
When was that?
My whole life. I started going to therapy when I was 10. So I've kind of just been doing it since then.
Are you taking any psychotropic medication other than the marijuana?
No.
Okay.
Judge, if I can just interject here, she, according to her PSI, has a diagnosis of depression and I think a personality disorder. I will say that the father of this child told our office when he was like, I'm not moving forward on her hitting me with the car, that he didn't want her to get in trouble because her mind tells her things that aren't true. So there might be a very big mental health issue here.
Yep, I see it. Thank you. All right, we also talked about an equation. I think there is an equation. First of all, she was ordered to not having marijuana. I wasn't aware of the medical marijuana. I don't know if probation or pretrial services was, but no physical or emotional abuse, no compliance with CPS orders or recommendations, no ability to disobey or not comply with CPS or family court orders. And there was no appropriate supervision of the child. All of these things were ordered. And what I get is a no, 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 which means 0 plus 0 plus 0 plus 0 plus 0 equals nothing. What I do have in this equation is a lot of excuses, a lack of accountability and responsibility. You're crying out, and as you sat over there, you did this. And you were shaking your head and making fun of what was being said. And downstairs, it was reported. And I heard your attorney say, don't say anything. Well, it comes back to me, your attitude and what was said down there. You don't really care, man. The root of the problem is you. When you have a child, laundry, cooking, whatever, you make sure that child is safe. You put him in a pen, in a walker. You bring the laundry out to the child. Bring the laundry and the child together. Bring the child to the laundry room. Show them how to fold. They might toss a few washcloths or something and have fun with it. There's lots of things you can do to make sure your child is safe. And you have not done that. The charges that I have in front of me are very, very serious. I am revoking bond, and in regard to the probation file, I don't know what I will do on that, except that I am extending it to the full 36 months. You will not have any contact with the victim, Mr. Smith, and any phone calls or other contact with your mother or with your children or the telephone will be appropriate, or that will also be denied.
So I can't have phone calls with my mom or the kids?
You can, as long as they're appropriate. Keep in mind, the people listen. And if you do anything that is inappropriate, I will suspend any communication outside of the jail.
Judge, I'm asking that you have a no contact with the victim in this case, which is also the 14-month-old Helena. I understand if you want to allow contact with her other children via the phone call, But
That's fine. Yeah, I think that's appropriate. So no contact with a 14-month-old. I don't know how much they communicate anyway, but she is a victim, so no contact with any victim or witness. We have to keep children safe. Children don't have a voice. As a parent, you have a higher responsibility to care for them. You are their voice. You are their safety net. I haven't seen that, ma'am. I also, while you are in lockup, we're going to get you a psychological evaluation. I'm not sure if they can do that there or we send you to forensics, but ma'am, you have a diagnosis. And I'm not a pharmacist or a doctor, but they have lots and lots of medications. I suspect you're using the marijuana to deal with depression and what have you. That's insufficient. You need to get on whatever regimen so you think better and your emotions don't get the best of you. Because that's what I see in this file is you're not thinking clearly and you act before you think. If you had cancer, you'd go to chemo. You'd take whatever treatment the doctors offered. There is no embarrassment with mental illness, depression, anxiety, whatever it is. It's a sign of strength to take your medication, to get evaluated, and work with doctors to find the right fit, which may take some time. So until I can be sure that you have appropriate treatment, following orders, and make everyone around you, especially your children, safe, you're in lockup. So this is for the safety of yourself, the community, and your children. For those reasons, I'm revoking bond this time. Anything further?
Nothing from the defender, no, sir.
On behalf of the people,
I just want to make sure that the order specifies that she can have supervised contact via jail calls with her other children, just so it's clear. Okay.
sure, we'll have supervised contact
Thank you.
with the other children. And the children then will be overlaid with the father. Children shall not be watched by any family member. The children now will be in the sole care and custody of the father.
Thank you, Your Honor.
And the grandmother is not allowed to be the daycare provider. He'll have to find other means. And I assume that's what he will do. It seems to me that he's trying to do that.
Thank you, Your Honor.
There's the family court involved, so they can work with him further if he needs childcare, other assistance, and he can also reach out to CPS. There are agencies and funding available, so he can work within the network that is available. And certainly there's the family court judge. Who's your judge, ma'am?
I don't know.
Okay, well, we'll figure that out. Anything further?
No, Your Honor.
Your Honor, you're going to want an order, I'm assuming, and I
It's
just
gonna
want,
be on the court note, so
okay.
I
I just
think
didn't
that
want to
should be-
skip something.
yeah, so we can get you all a copy of the court note, and I'm going to order a copy of this transcript to the family court judge for review. Usually I can go down and tell them, but I think this warrants family court judge to receive a copy of the police report, the people's motion, a copy of the transcript, and my April 15 order amended bond. Those items would be attached to the family court, or I'm sorry, to the transcript for the family court judge. Anything further?
No, Your Honor. Thank you.
No, Your Honor, thank
Good
you.
luck to you, ma'am. We have services there. Avail yourself of them if you have any hope of getting out sooner. Thank you.
Really? All of my chats just crashed at the same time. It's not fair. Oh, snap. Reload. There we go. She gave full care and custody to the father there at the end, ladies and gentlemen. I'm not sure if everybody heard. That was, that's how that panned out. Mom went to jail. for an indefinite amount of time until she can figure out that she's going to be safe. Who knows? It's actually probably going to be up to another judge altogether, not even Judge Aquilina. Judge Aquilina just had an emergency motion in front of her because most of that stuff we were hearing about happened yesterday. Thank you so very much, Patrick. I do want to say a very big, oh my goodness. I had everything like panned out right over here. Vega. I don't see your whole name. Why don't I see your whole name? Vega Starlight. Oh, thank you so very much for that super chat. And Specs, spending coffee money on this community is worth it. I thank you so very much for a little bit of coffee money. And Darth Steven, I don't think I even got to see that one when it happened in chat. I apologize. Thank you so very much for your super chats. It means the world to the Wolfie and the little pups. And I do want to say thank you to a bunch of other people too. This is how we do that. There's that Vega, Specs, Darth Steven, Barry and Rhonda. Thank you so much for hanging out. Mama, thank you so much for hanging out tonight. Why is my name up there? My name's, I could never figure this out. Math Girl, thank you for being here tonight. Jamurger, thank you for being here. Hutch, Nichelle, I like to say that name. Nichelle, Donald, ahoy. See you next time, my friend. John Quattlebaum, great to see your name again. This is like 2 or 3 times in a row. It's becoming an absolute regular, like a lot of these other people right here. Marty, looking at you, buddy. Better get that last word in tonight. Me and Mom have a little game where we actually watch to see if Marty's going to actually get the last word every single night. I shouldn't tell him that, should I, Mom? But it's true. Hutch, what's up, buddy? What's up? Darth Steven, may the farce be with you, friend. And ladies and gentlemen, don't forget, where there be more court, there's going to be a little bit more wolf. We're going to do this again tomorrow night. Same wolf time, same wolf channel. I'll probably have several more cases for us to go through. Tonight just happened to be, Judge Simmons, Judge DiSanto, and Judge Aquilina. I couldn't even plan that out. When I saw those cases, it just fell right into place for me. Especially that last one. That was crazy. I am your lone wolf Usul, and I am out of here. Isn't it? I am out. Oh well, I'll get it right somehow. Little bit of action midstream there where Mama Wolfie had an actual fox come sniffing up at her garage door. That was kind of crazy. And it went running off, and I'm pretty sure I've seen it running on my front porch. Interesting night. Hope the cats stay safe out there. And you. Yeah, you. There's nobody else here to talk to. I got nothing else. You be safe too. But go. Get out of here. Why am I even doing this? Bye.